Good day, guys. We are now going to discuss the more basic doctrines in commercial law under the subject of intellectual property rights. Let's begin. What is a patentable invention? Any technical solution of a problem in any field of human activity which is new, involves an inventive step, and is industrially applicable shall be patentable. It may be or may relate to a product or process or improvement of any of the foregoing. Next, what are non-patentable inventions? These are discoveries, scientific theories, and mathematical methods. 2. Schemes, rules, and methods of performing mental acts, playing games, or doing business, and program for computers. Third, methods for treatment of the human or animal body by surgery or therapy, and diagnostic methods practiced on the human or animal body. Fourth, plant varieties or animal breeds or essentially biological process for the production of animals or plants. Fifth, aesthetic creations. Sixth, anything which is contrary to public order or morality. Who has the right to a patent ownership? The right to a patent belongs to the inventor, his heirs, or assigns. When two or more persons have jointly made an invention, the right to a patent shall belong to them jointly. Section 28 of the Intellectual Property Code. In a commissioned work, who owns the patent? The person who commissions the work shall own the patent unless otherwise provided in the contract. In case the employee made the invention in the course of his employment contract, who should the patent belong to? The employee, if the inventive activity is not a part of his regular duties, even if the employee uses the time, facilities, and materials of the employer. The employer, if the invention is the result of the performance of his regularly assigned duties, unless there is an agreement, express or implied, to the contrary. What is the first to file rule? If two or more persons have made an invention separately and independently of each other, the right to the patent shall belong to the person who filed an application for such invention, or where two or more applications are filed for the same invention, to the applicant who has the earliest filing date or the earliest priority date. What is the right to priority? The application for patent filed by any person who has previously applied for the same invention in another country which by treaty, convention, or law afford similar privileges to Filipino citizens shall be considered as filed as of the date of filing the foreign application. What are the requirements for the right to priority? First, the local application expressly claims priority. B. It is filed within 12 months from the date the earliest foreign application was filed. C. A certified copy of the foreign application, together with an English translation, is filed within 6 months from the date of filing in the Philippines. What is the prior user rule? Any prior user who, in good faith, was using the invention or has undertaken serious preparation to use the invention in his business before the filing date or priority date of the application on which a patent is granted, shall have the right to continue the use thereof as envisaged in such preparations within the territory where the patent produces its effect. What are the rights conferred by a patent? A patent shall confer on its owner the following exclusive rights. First, where the subject matter of a patent is a product, to restrain, prohibit, and prevent any unauthorized person or entity from making, using, offering for sale, selling, or importing that product. B. Where the subject matter of a patent is a process, to restrain, prevent, or prohibit any unauthorized person or entity from using the process, and from manufacturing, dealing in, using, selling, or offering for sale, or importing any product obtained directly or indirectly from such process. C. Patent owners shall also have the right to assign or transfer by succession the patent and to conclude licensing contracts for the same. What are the grounds for the cancellation of a patent? That what is claimed as the invention is not new or patentable. Second, that the patent does not disclose the invention in a manner sufficiently clear and complete for it to be carried out by any person skilled in the art. Or third, that the patent is contrary to public order or morality. What is the effect of a cancellation of a patent? The rights conferred by the patent or any specified claim or claims cancelled shall terminate. What is patent infringement? The making, using, offering for sale, selling, or importing a patented product or a product obtained directly or indirectly from a patented process, or the use of a patented process without the authorization of the patentee constitutes patent infringement. What are the tests to determine patent infringement? Literal infringement and doctrine of equivalence. What is literal infringement? To determine whether the particular item falls within the literal meaning of the patent claims, the court must juxtapose the claims of the patent and the accused product within the overall context of the claims and specifications to determine whether there is exact identity of all material elements. What is the doctrine of equivalence? An infringement takes place when a device appropriates a prior invention by incorporating its innovative concept and, although with some modifications and change, performs substantially the same function in substantially the same way to achieve substantially the same result. The doctrine of equivalence thus requires satisfaction of the function, means, and result test. The patentee have the burden to show that three components of such equivalency test are met. What is a mark? Any visible sign capable of distinguishing the goods or services of an enterprise and shall include a stamped or marked container of goods. What is a trade name? The name or designation identifying or distinguishing an enterprise. How is the right over a mark or trade name acquired? The rights in a mark shall be acquired through registration made validly in accordance with the provision of this law. Trade names shall be protected even prior to or without registration against any unlawful act committed by third parties. What are non-registrable marks? A mark cannot be registered if it consists of immoral, deceptive, or scandalous matter, or matter which may disparage or falsely suggest a connection with persons, living or dead, institutions, beliefs, or national symbols, or bring them into contempt or disrepute. Second, consists of a flag or coat of arms or other insignia of the Philippines, or any of its political subdivisions, or of any foreign nation, or any simulation thereof. Third, consists of a name, portrait, or signature identifying a particular living individual, except by written consent, or the name, signature, or portrait of a deceased president of the Philippines during the life of his widow, if any, except by written consent of the widow. D. Identical with a registered mark belonging to a different proprietor or a mark with an earlier filing or priority date is in respect of: first, the same goods or services; second, closely related goods or services, or if it nearly resembles such a mark as to be likely to deceive or cause confusion. It is identical with or confusingly similar to or constitutes a translation of a mark which is considered by the competent authority of the Philippines to be well known internationally and in the Philippines, whether or not it is registered here, as being already the mark of a person other than the applicant for registration and used for identical or similar goods or services. Provided that in determining whether a mark is well known, account shall be taken on the knowledge of the relevant sector of the public rather than the public at large, including knowledge in the Philippines which has been obtained as a result of the promotion of the mark. It is identical with or confusingly similar to or constitute a translation of a mark considered well known in accordance with the preceding paragraph, which is registered in the Philippines with respect to goods or services which are not similar to those with respect to which registration is applied for, provided that the use of the mark in relation to the goods or services would indicate a connection between those goods or services and the owner of the registered mark, provided further that the interests of the owner of the registered mark are likely to be damaged by such use. Next, it is likely to mislead the public, particularly as to the nature, quality, characteristics, or geographical origin of the goods or services. H. Consists exclusively of signs that are generic for the goods or services that they seek to identify. Consists exclusively of signs or of indications that have become customary or usual to designate the goods or services in everyday language or in bona fide and established trade practices. It consists exclusively of signs or indications that may serve in trade to designate the kind, quality, quantity, intended purpose, value, geographical origin, time or production of the goods or rendering of the services or other characteristics of the goods or services. K. Consists of shapes that may be necessitated by technical factors or by the nature of the goods themselves or factors that affect their intrinsic value. L. Consists of color alone unless identified by a given form. Or last, it is contrary to public order or morality. What is the prior user rule? Any prior user who is in good faith was using the invention or has undertaken serious preparations to use the invention in his enterprise or business before the filing date or priority date of the application on which a patent is granted shall have the right to continue the use thereof as envisaged in such preparations within the territory where the patent produces its effect. What are tests to determine confusing similarity? Dominancy test, holistic test, and idem sonance test. What is the dominancy test? The dominancy test considers the similarity of the prevalent dominant features of the competing trademarks that might cause confusion, mistake, and deception in the mind of the purchasing public. More consideration is given in the oral and visual impressions created by the mark on the buyer of goods, giving little weight to the factors such as process, quality, sales outlets, and market segments. What is the holistic test? 3, 2, 1. What is the holistic test? The holistic test considers the entirety of the marks as applied to the products, including the labels and the packaging, in determining the confusing similarity. The focus is not only the predominant words, but also on the features appearing on the labels. What is the idem sonance test? A test used to determine confusing similarity of two marks based on similarity of sounds or pronunciations. What are rights conferred by registration? Exclusive right to prevent all third parties not having the owner's consent from using the course of trade identical or similar signs or containers for goods or services which are identical or similar to those in respect of which the trademark is registered, where such use would result in a likelihood or confusion. Second, the exclusive use to the use of the mark and sue for infringement. What are the elements of trademark infringement? The trademark being infringed is registered in the Intellectual Property Office. The trademark is reproduced, counterfeited, copied, or colorably imitated by the infringer. The infringing mark is used in connection with a sale, offering for sale or advertising of any goods, business or services, or the infringing mark is applied to labels, signs, prints, packages, wrappers, receptacles, or advertisements intended to be used upon or in connection with such goods, businesses, or services. The use or application of the infringing mark is likely to cause confusion or mistake or to deceive purchasers or others as to the goods or services themselves, or as to the source or origin of such goods or services or the identity of such business. The use or application of the infringing mark is without the consent of the trademark owner or the assignee thereof. What is the most essential element of trademark infringement? The infringing mark is likely to cause confusion based on the case of Bodytrans Manufacturing versus Davidoff. What is unfair competition? The passing off or attempting to pass off upon the public of the goods or business of one person as the goods or businesses of another with the end and probable effect of deceiving the public that the goods are those of his competitor. Intent to deceive must be established. What is the effect of registration under the Madrid Protocol? The protection resulting from the international registration shall extend to any contracting party only at the request of the person who files the international application or who is the holder of the international registration. No such request can be made with respect to the contracting party whose office is the office of origin. Every international registration shall enjoy the right of priority for 6 months. The period of validity of international registration of a mark at the International Bureau is 10 years, which may be renewed for another 10 years from the expiration of the preceding period upon payment of fees. What is the right to literary and artistic works which are original intellectual creations in the literary and artistic domain, protected from the moment of their creation? Copyright, based on the case of Co versus CA. Registration of a copyright is required. True or false? False. With regard to authors, how long shall a copyright last? During the author's lifetime and 50 years after his death. What are non-copyrightable works? Any idea, procedure, system, method or operation, concept, principle, discovery, or mere data as such, even if they are expressed, explained, illustrated, or embodied in a work. Second, news of the day and other miscellaneous facts having the character of mere items of press information or any official text of a legislative, administrative, or legal nature, as well as any official translation thereof. What are the economic rights of the copyright owner? The exclusive right to carry out, authorize, or prevent the following acts. First, reproduction of the work or substantial portion of the work. Second, dramatization, translation, abridgment, arrangement, or other transformation of the work. Third, the first public distribution of the original and each copy of the work by sale or other forms of transfer of ownership. Fourth, rental of the original or a copy of the audiovisual or cinematographic work or a work embodied in a sound recording, a computer program, a compilation of data and other materials, or a musical work in graphic form, irrespective of the ownership of the original or the copy which is the subject of the rental. Fifth, public display of the original or a copy of the work. Sixth, public performance of the work. And seventh, other communication to the public of the work. In case of original literary and artistic works, copyright shall belong to whom? The copyright shall belong to the author of the work. In the case of original works of authorship, who shall be the original owners of the copyright? Co-authors shall be the original owners of the copyright. In the absence of agreement, their rights shall be governed by the rules of co-ownership. In the case of work created by an author during and in the course of his employment, the copyright shall belong to the employee, provided that the creation of the object or of copyright is not a part of his regular duties, even if the employee uses the time, facilities, and materials of the employer. True or false? False. In the case of work created by an author during and in the course of his employment, the copyright shall belong to the employee, even if the creation of the object of copyright is not a part of his regular duties, even if the employee uses the time, facilities, and materials of the employer. In the case of work created by an author during and in the course of his employment, the copyright shall belong to the employee if the work is the result of the performance of his regularly assigned duties, unless there is an agreement, expressed or implied, to the contrary. True or false? False. In the case of work created by an author during and in the course of his employment, the copyright shall belong to the employer if the work is the result of the performance of his regularly assigned duties, unless there is an agreement, expressed or implied, to the contrary. In the case of a work commissioned by a person other than an employer of the author and who pays for it, and the work is made in pursuance of the commission, who owns the work? The person who so commissioned the work shall have ownership of the work. In the case of work commissioned by a person other than an employer of the author and who pays for it, and the work is made in pursuance of the commission, who owns the copyright? The copyright thereto shall remain with the creator. What is the exception to the rule for copyright and ownership of a commissioned work? When there is a written stipulation to the contrary. What is the rule on copyright ownership in audiovisual works? In the case of audiovisual work, the copyright shall belong to the producer, the author of the scenario, the composer of the music, the film director, and the author of the work so adapted. However, subject to contrary or other stipulations among the creators, the producer shall exercise their copyright to an extent required for the exhibition of the work in any manner except for the right to collect performing license fees for the performance of musical compositions with or without words, which are incorporated into the work. For letters, who owns the copyright? respective letters, the copyright shall belong to the writer, subject to the provisions of Article 723 of the Civil Code. Discuss the four-factor test to determine fair use. In determining whether the use made of a work in any particular case is fair use, the factors to be considered shall include: first, the purpose and character of the use, including whether such use is of a commercial nature or is for a non-profit educational purposes. Second, the nature of the copyrighted work. Third, the amount and substantiability of the portion used in relation to the copyrighted work as a whole. And D, the effect of the use upon the potential market for or value of the copyrighted work. What is copyright infringement? Consists in doing by any person, without consent of the owner of the copyright, of anything the sole right to do which is conferred by statute on the owner of the copyright. On the case of Columbia Pictures versus Court of Appeals. What are the remedies for the copyright owners against the infringers? First, to file an action for injunction. Second, to claim for damages. Third, claim for payment of moral and exemplary damages. Fourth, deliver under oath for impounding during the pendency of the action upon such terms and conditions as the court may prescribe, sales invoices and other documents evidencing sales, all articles and their packaging alleged to infringe a copyright and implements for making them. Fifth, deliver under oath for the destruction without any compensation all infringing copies or devices, as well as all plates, molds, or other means for making such infringing copies as the court may order.